Hello, I'm attorney David Abrams. And of course, the news that's rocketing not just the legal world, but the entire American society right now is the Supreme Court decision in Dobbs versus Jackson Women's Health, which dropped on Friday. And unusually in this case, we got to see a draft of the opinion, which caused quite an uproar, and I did a video on that. But now we've gotten to see the actual decision, and certainly the ruckus that came after the draft did not dissuade Justice Alito. In fact, I would say he doubled down on what he wrote in the initial decision, and that the final decision is actually more radical and just a bigger decision than even the initial draft led us to believe. Justice Alito was joined in the decision by Justice Gorsuch, Justice Kavanaugh, Justice Thomas, and Justice Barrett. All Republican appointees, three of them somewhat controversial appointees. So that could be a problem in getting the public to accept this decision. And we saw, Justice Alito left in the thing about the history. The actual published decision is 236 pages. It's a long decision, 236 pages. And again, he really doubled down on the issues in the draft. This is an unequivocal rolling back of Roe, and it's not where it left something intact. It is basically saying that there is no constitutional right to any kind of protection. There's no limitation on what the state can do in terms of controlling women's access to abortion services during their pregnancies. There's just no right of privacy during pregnancy for women. It is a really extreme decision. The kind of radical change you rarely see in the law. And he takes a lot of, one of the things that we didn't see in the draft that we're seeing now is Justice Alito spent a lot of time talking about substantive due process. And that's a topic that I think a lot of people don't understand what that is. And you actually spend an entire semester in law school really studying substantive due process cases. And the idea behind substantive due process is that not all the rights that we have as Americans are specifically articulated in the Constitution. For instance, there's no right in the Constitution for marriage. The Constitution doesn't talk about marriage, right? There's no right in the Constitution to raise your children, right? There's no right to access birth control, right? There's no right to be free from sterilization, right? All these things. And these are all issues that came up before the court and were decided under substantive due process basis. And it's all tied to the 14th Amendment, which was a Civil War amendment. And it's really interesting because Alito really writes in a style that's very reminiscent of Scalia. He's very mocking of the other side. He's very mocking of the justices that were on the bench who decided Roe, and of his predecessors on the bench. This decision is not kind towards them. It really is very hostile towards them. And one of the things that he does in this case is he really mocks their language. And he talks about how they referred to fetuses as potential life. And you see in this opinion where he's shifting the language. He's going from potential life to fetal life, and then as he moves through the decision, he brings it to prenatal life. So he's really coming down on the side of life begins at conception. So he's saying, he's basically making that the law in the United States, is that life begins at conception. And I think that's an important point, because I think that could be something that we're going to be dealing with for a long time to come. And that could have implications in terms of how much influence can a state take to force health care on women during their pregnancies. can they criminalize a woman smokes or has too much alcohol or whatever during their pregnancies? This idea that this is life already, that life begins at conception, could really open up the door for a lot of coercive behaviors by the government. And what's interesting is he really writes like the court is doing something that he sees as very, just righting a tremendous wrong. And he compares this decision to Brown versus Board of Education. He talks about the Brown upended, all the segregation cases, and here they are, they're now doing the same thing for prenatal life. So it's very much a life begins at conception approach to the law. Even though he would tell you that that's not something that he thinks the law should be deciding, and it goes to the states, right? The appendices that he attaches to the decision are all 19th century, many early 19th century cases that have to do with quickening fetuses and things like that. And he uses those to, as we saw before, to give historical justification with the argument that abortion has never been part of the history and traditions of the country, notwithstanding the fact that safe elective abortions were not available through much of history. This is really something that, from a technological standpoint, wasn't even an issue, right? You couldn't have a safe elective abortion, at least not safe by modern standards, up until really the 1940s, maybe 1950s, right? Remember, we didn't have antibiotics until right around World War II. Justice Thomas's concurrence, he writes a concurrence. He joined in the decision, but then he writes his own decision. And his decision is the part where I think, we're seeing the future. Justice Thomas takes issue with substantive due process. And he basically, where Alito is saying, nothing here affects these other substantive due process cases, Thomas says no, that substantive due process, he actually refers it to as an oxymoron that lacks any basis in the Constitution. Right? And he actually writes that the court should reconsider all of the court's substantive due process precedents. And that is something that I don't know, it makes me really take pause and wonder where American jurisprudence is heading, because what we're talking about are cases like access to birth control, right? The Griswold case. You're talking cases like Loving versus Virginia. They found unconstitutional state laws that barred marriage between people of different races. It would be cases, the Yoder case, where the Constitution doesn't say you have a right to educate your children, but Yoder was a substantive due process case that said Amish parents have the right to educate their children in the Amish traditions and teach them how to be farmers, right? All of these cases, Obergefell, the right to gay marriage, right? Lawrence versus Texas, the right to basically have freedom in your sex life, right? Where the state can't necessarily outlaw sodomy. You get to decide what you and a loving partner want to do together. All of those things are at least in Thomas's radar, things that the courts should reconsider, and I think he believes that they should be reversed. And honestly, I think we're at the point where this is Thomas's court. I think this is quite possibly what we're going to see coming down from this court. Right? This court, there's a thing in the law where they took the hatchet to it or the meat axe. Right, the hatchet meaning they took little pieces out of the law, or things like that. And then there's the meat axe, right, where they take big chunks. This is the meat axe. This is the frickin' chainsaw, right? At least from Thomas's perspective, and it begs to be seen how far his conservative colleagues on the court are actually going to go. Justice Kavanaugh writes a concurring opinion. Basically, what I saw in Justice Kavanaugh's opinion was he just toned down the rhetoric. He I think was trying to distance himself from the almost really insulting criticism of his predecessors on the court that was that's contained in the Alito decision. And then Chief Justice Roberts also writes a concurring opinion, and Roberts actually makes an interesting point. Is he says, look, the issue of the constitutionality of Roe is not before this court today. And the only thing we should be deciding is whether all pre-viability bans are unconstitutional. That was the issue they took certiorari on, and he said that's what we should be deciding. We don't need to go and do all of this. But he agrees that that Roe is unconstitutional. So it doesn't really do much good. It doesn't really make much difference. And I think it also shows that Roberts is not leading the court. Right? The court is doing its own thing. I think he's got diminishing influence with this kind of hyper-conservative block of justices. And then there's a dissent by Justice Breyer, Justice Sotomayor, and Justice Kagan. And the dissent is actually, it's long. It's actually a long dissent. And they point out that time and time again the court has upheld the privacy right behind Roe and substantive due process, and they really point out that the majority in this case is just disregarding all of that, and that the majorities claim that they're not just arbitrarily overturning precedent doesn't really hold water with them. And there's a couple things in there that they wrote that I thought were interesting. One of the things they wrote is that when they're looking at the 14th Amendment, where the majority wrote that the people passed the 14th Amendment, and the dissenting judges wrote that people did not ratify the 14th Amendment, men did. And they pointed out, and I think historically accurately, that at the time the 14th Amendment was passed, women were basically property owned by their husbands. They pointed out a case where a woman who was married was denied a law license, and the Supreme Court upheld that. Women were not seen as full and equal citizens. And I think the dissenters have very good points that we don't live in that era, or we thought we didn't live in that era. I think that the majority seems like they would be much more comfortable, or that they don't have a problem with returning to that era. The question now is, where does this go? And on a national level, I think it's all going to be whether or not these conservative justices, how far are they willing to take it at deconstructing substantive due process rights, and are they such quote unquote textualists that they will not recognize any right other than those specifically enumerated in the Constitution? If that's the case, then I think you can expect to see gay marriage fall. I think you can expect to see, I actually expect that you'll see one of the first things that'll come down will be restrictions on minors' access to birth control. But I think you will see some issues coming up with certainly abortion-related things, the morning after pill. I think you'll see state legislators moving to limit those. And I would not be at all shocked to see legal issues arising out of state statutes that criminalize crossing a state line to obtain an abortion. I think that's an entirely possible scenario. I think that gay marriage again is probably going to come up again, and I think that this court will knock down the constitutional right to gay marriage. Here in the state of Florida, I do want to say one thing is that we don't know the answer yet. Is Florida actually has a privacy provision in the state constitution that the legislative history seems to indicate that was put in place, that this privacy provision in our state constitution was put in place in case Roe was ever overturned. And the question is whether or not the Florida Supreme Court will uphold that right, will read that provision to say that privacy includes the right to abortion, the right to birth control, the right to have the type of sex that you want, all of those things that come through substantive due process. And I don't know, we're going to have to see what happens. We have a lot of very conservative members on the Florida Supreme Court right now, a lot of people from the Federalist Society. And again, this is a philosophical shift in American jurisprudence that's happening right now. Part of what I think is, if you look at the history of American jurisprudence, American courts were really very conservative up until after World War II. And American courts really, I think, were very textualist oriented up until World War II. And I think they followed a lot of the legal positivism that existed in the German courts during the Nazi era, and even leading up to the Nazi era. And part of what I think that generation saw was that hypertextualism, that this idea that courts are not concerned with justice, that outcomes of cases are not the concern of judges, that was actually a dangerous idea that allowed the courts in Nazi Germany to not stand up when they were putting Jews in ovens, right? That was all done legally, right? The recent published book, Caste, gives a good history of how the Nazi legislators actually looked to American race law to help draft the laws against Jews during Nazi Germany. And again, these were all judges who, at that time, I think the dominant legal philosophy was this legal positivism, which has now been rebranded as just textualism, right? It's kind of the gist of the Federalist Society. And so I think that we're in an era where legal positivism and or textualism, depending what you want to call it, is on the rise. And I don't think that's right. I think that judges need to be concerned about the outcomes of cases. I don't think that's everything, right? I think that you always start with the text. But I don't think that saying that, judges saying that, what happens when it leaves our courtroom isn't really our concern, I don't see how that makes any sense. There's a biblical story about the destruction of the temple in the Jewish world that says that the first time that the temple was destroyed, God destroyed the temple because people weren't following the law. And that the second time the temple was destroyed, it was because people were following the law, but they weren't being compassionate in it. In other words, they were following the text perfectly, but they weren't humanizing the law. And I've always thought that's a great metaphor. Whether or not you believe, or you're a religious person or anything, I've always thought that's a great illustration about what law should be, is that we can't be so strict with the law that we ignore the effects of the law. Nor should we ignore the law either. We shouldn't, become lawless. So I wish I had great news for you. I think this court is going to radically change American society. I think that a lot of the advances of the Warren Court now are in jeopardy, absent government. There's something happening in the government to expand the court. I really think that's the only option that's available right now to try to protect rights that I think most Americans really support. And that's my read of Dobbs versus Jackson Women's Health Organization. Thank you for listening.